Namaste, good morning. Welcome to 109th episode of AAA Weekly Webinar Series. It is the continuation of our efforts, and today we are deliberating on some of the very significant judgments of Honorable Supreme Court and also some of the High Courts on SARFAESI law. The very significant impact that we could see from SARFAESI Act is that the SARFAESI Act is now becoming more stable and effective, and the recoveries are, in fact, when we compare it with IBC, the SARFAESI is more effective and faster. Except a couple of debt recovery tribunals where the stay is granted for some period and there is a possibility of delay. Otherwise, the various judgments from Honorable Supreme Court regarding SARFAESI law actually has helped us overcome the difficulties regarding provident fund dues, as we see in IBC, gratuity dues, as IBC actually having a trouble of gratuity dues. Then the secured operational creditors, for example, the dues of income tax department, dues of state VAT tax. So these are the difficulties that we are facing in IBC, whereas in SARFAESI, these difficulties have been overcome by various judgments of Honorable Supreme Court. So we are again emphasizing that the SARFAESI is a better mode where the properties are identifiable, properties are sellable, and the size of the properties are not very large, because then we are able to find buyers under SARFAESI. So the only thing that the banks are facing difficulty is that they are not able to find buyers. So therefore, there is a need for a platform so that all the buyers can come and they can find out the assets under stress which are available for sale. So that is what is also kind of need of the hours. Therefore, we also started bankofstressed-assets.com, where all the assets which are available on auction, maybe under SARFAESI, DRT, High Court, or even income tax, those are all posted, and we are inviting the buyers on that particular portal, bankofstressed-assets.com. So, like going to the very important judgment that we would actually discuss at the first instance, I would give me a minute. And the very important judgment that we are going to discuss is basically the judgment in the name of Haldiram Incorporation Private Limited versus Amrit Hatcheries Private Limited. In fact, Haldiram purchased a property. Amrit Hatcheries is the name of the corporate debtor. Purchased a property of Amrit Hatcheries. It is a Supreme Court judgment, and the date of the judgment is 6th of December 23, and it is from Honorable Supreme Court of India. So in this case, the basic issue before the Supreme Court of India was whether the completion of sale under SARFAESI Act prior to the declaration of moratorium under IBC preclude the treated properties from being considered part of the liquidation estate in subsequent liquidation proceedings. That is the main issue. In fact, when we see the facts of the cases, that a sales certificate was issued under SARFAESI Act, and that was regarding one of the immovable property. Then thereafter, the operational creditor filed a Section 9 petition and the case was admitted. Now, NCLT found that the sales certificate was issued and the property was handed over to the, it was considered as illegal. The NCLT found that the property was handed over to the buyer, means Haldiram, in illegal manner, and the sales certificate was also issued illegally. And then Punjab National Bank filed an appeal before NCLAT. In that appeal also, although the appeal was it was also the upheld, but one of the technical member was having a dissenting view in that judgment. Finally, when it went to the Supreme Court says the sale under SARFAESI Act was concluded before the declaration of moratorium. Now, the fact was that in this case, the sales certificate was issued and it was almost a kind of alleged that it is issued hurriedly. The payment was received. However, the registration of the sale deed was not done. So therefore, the NCLT thought that still the property is in the name of the corporate debtor and will be considered as part of the liquidation estate. The Supreme Court of India, in fact, referred the judgment of SJP Impacts Private Limited versus Assistant General Manager and Authorized Officer of Canara Bank. That judgment, in fact, in that judgment, it is a judgment of 2021. In that judgment, the Supreme Court held as under. We are of the view that mandate of law in terms of Section 17, subsection 2, clause 12, read with Section 89, subsection 4 of the Registration Act 1908, only required the authorized officer of the bank under the SARFAESI Act to hand over the duly validated sales certificate to the auction purchaser with a copy forwarded to the registering authorities to be filed in Book 1 as per the Section 89 of the Registration Act. Then another judgment was referred by Supreme Court in this judgment of Haldiram. In this, it is said in this particular case that the same view was taken. Subsequently, it was taken by a coordinate bench of this court, means Supreme Court of India, and that was in the name of Inspector General of Registration and others versus G. Madhurambal and others, and that was decided on 11th of November 2022. Now, when we actually went to the Registration Act, we saw Section 89 of the Registration Act, and in fact we found that the special SLP against Madras High Court judgment holding that registering authority cannot demand stamp duty to keep a copy of the sales certificate on the file of book number 1 was dismissed. An issue has been repeatedly settled, and a consistent view has been followed for the last 150 years. The practice and procedure in that particular judgment, it was also said that it is the time that the authorities means all these stamp duty authorities, should stop filing unnecessary special leave petitions only with the objective of attaining some kind of final dismissal from this court every time. Then Section 17, subsection 2, clause 12 of the Registration Act also, we in fact tried to read, and it says, documents of which registration is compulsory. Now it says 1, 2, 3, 4, and then finally it says that nothing in clause B to C applies to clause 12. Any certificate of sale granted to purchaser of any property sold by public auction by a civil or revenue officer. This is what was told here in this section 17, subsection 2, clause 12. Now, this is like when we saw this judgment of Madhurambal judgment, November 2022, it was very clear. The Supreme Court says that the authorities should stop filing the unnecessary special leave petitions, ask for the stamp duty. The Section 17, subsection 2 is very clear that it is if sold by public auction by a civil or revenue officer. That means the sale under SARFAESI Act is also akin to sale by a public auction by a civil or revenue officer. That's what I could understand, because see, the Section 17 of the Registration Act says that the sold by public auction by a civil or revenue officer. So this is something which is now we can assume that the sale under SARFAESI is basically sale by public auction by a civil or revenue officer. I can even assume that the sale by a liquidator under auction is also by an officer appointed by the court. If a SARFAESI sale would be exempt from stamp duty, therefore even the liquidation sales. sales under liquidation, where the liquidator is appointed by the court, that also should be considered as public auction by a civil or revenue officer, because there are 3 or 4 judgments of Honorable Supreme Court where it is said that the SARFAESI sales are actually covering under this section 17, subsection 2 and clause 12. When we say this, that actually means like SARFAESI is also sold by the authorized officer. Authorized officer is empowered to sell out under the SARFAESI Act. Similarly, the liquidator is authorized to sell, and liquidator is appointed by the court, and the liquidator is authorized to sell under the law. Therefore, the sale under the liquidation process also should be covered by this particular section of Registration Act. Although the courts have been insisting, like there are various stamp duty authorities, they are coming back again and again to Supreme Court, but Supreme Court is holding on to this decision that only sales certificate, the only requirement that the Supreme Court says that whenever sales certificate is executed, the seller has additional responsibility that the seller will forward a copy of that sales certificate to the registration, to the jurisdictional registration authority, so that with the direction that this particular sales certificate may be recorded in Book 1 under the Registration Act, and it should be registered. The importance is registration. Stamp duty is required for registration. If the registration is done as per law, then stamp duty is not required. That is what probably the meaning of these judgments are. Now, when we see this section 89 of the Registration Act, the heading is copies of certain orders, certificates, and instruments to be sent to registering officer and filed. Subsection 4 of Section 89 of the Registration Act says, every revenue officer granting a certificate of the sale to the purchaser of immovable property sold by public auction shall send a copy of the certificate to the registering officer within a local limit of whose jurisdiction the whole or any part of the property comprises in the certificate is situated. And such officer shall file a copy in his book number 1. Now, let us try to understand now what I am trying to conclude. What I am trying to conclude is that 1 is the judgment of Haldiram Incorporation Limited versus Amrit Hatcheries. This particular judgment is dated 6th of December 2023. And before that, there is a judgment which is in the name of G. Madhurambal and others, Inspector General of Registration, Inspector General of Registration and another. In this case, Inspector General of Registration was claiming that the stamp duty has not been paid. So in this case, the Supreme Court decided on 11th of November 2022 that no stamp duty is payable if the sales certificate has been executed and it is actually been forwarded to the registering authority. Then the other case that is referred in this case is SJP Impacts Private Limited versus Assistant General Manager and Authorized Officer of Canara Bank. That is a judgment which is slightly later. It is in December 22. So basically now we are referring to 3 judgments which are very clearly saying that when a sales certificate is issued by a revenue officer, so the SARFAESI officers are considered revenue officers. Similarly, I believe that the officer, like the liquidator appointed by the NCLT, when the liquidator is selling the properties, so the liquidator issues sales certificate, all the liquidators are supposed to forward a copy of the sales certificate to the registration authority, and the registration authority will register it in book number 1, and that is where it is called document registered. So the sale is registered with the registration authority, so therefore no stamp duty is required. This is what Honorable Supreme Court is maintaining for the last 150 years, and now the Supreme Court says, and asking the authorities, don't come and file appeals again and again. We will give the same judgment again and again. So this is something which is a very, very important finding that I could find, and the trigger came only when this judgment of Haldiram came. And unfortunately, this Amrit Hatcheries is also a case where earlier the one of the partner of AAA insolvency was RP, and however the liquidation was given to somebody else. But this case, in fact, started much before the liquidation, because this case, in fact, the property was sold much before the start of the IBC, CIRP. So this is something which is very important. Let me see in case if there is any question on this. So what I'm saying, there is a question from the DSR, and it seems to be an IRP. The question is, can liquidator under NCLT selling asset under IBC, no stamp duty required for registration of sales certificate? I'm trying to make out a case like this only, because see, if the SARFAESI, the sale is being made by authorized officer of the bank, who is a class 4 or above officer as per the SARFAESI law, and the authorized officer is authorized to sign the sales certificate, and the only requirement under the Registration Act is that the sales certificate has to be forwarded to registration authority with a direction to register this document in Book 1. So therefore, when I compare SARFAESI and insolvency, I find there is no gap. That is also being sold by an authorized officer, authorized by a law, which is SARFAESI law, and the liquidator is also selling assets, and that those assets are also being sold under the powers of a law, and his appointment is also from the NCLT. Now, the question from the same person is this: suppose if the auction purchaser has only sales certificate, can he make subsequent sales, as the subsequent purchaser will insist for a registered document in the name of the auction purchaser? One, that the sales certificate is in the name of the buyer. So there is no difference in, like, the name can be the same, name is the same, either it is mentioned in the sales certificate or it is mentioned in the sale deed. Secondly, now the Supreme Court says that it is the obligation of the registration authority to register the sales certificate in Book 1. Second requirement for a proper title is that it should be a registered document under the Transfer of Properties Act. So the second requirement is being met by the Registration Act, Section 17 of the Registration Act, and Section 89, subsection 4 of the Registration Act. So therefore, one, the sales certificate actually has the name of the buyer. Number two, the sales certificate is registered by the registration authority. So therefore, the title is complete, and whenever he would be selling in future, I don't think there will be any difficulty in selling. Now, Naveen Anchan is asking, does this imply that the stamp duty is not payable by the buyer of the property purchased under SARFAESI? Yes, that is what I am trying to conclude. I have given 3 judgments of Honorable Supreme Court, and Honorable Supreme Court has also said to the authorities of the Stamp Duty Act that don't come again and again to Supreme Court. We are maintaining the same. Thing, and it is something which is almost concluded. So don't file unnecessary litigation. And then again, the SD Gupta CMA is asking, where is the format of sales certificate? The sales certificate format can be made. The sales certificate should include the description of the property, the power of the seller, and the process conducted, and the auction conducted. Everything should be mentioned in the sales certificate. It should also mention that the buyer is eligible. So all this should be mentioned in the sales certificate. The entire description should be mentioned. Description of the property should be mentioned in the sales certificate. And if there is a condition, if there is any condition, if there is any obligation on the buyer, that also should be mentioned in the sales certificate. So that is what is the sales certificate, and also how the first of all the registered owner, how the registered owner became the owner of that property. Then how the registered owner mortgaged that property, how the mortgage was effective, and finally the authority who is selling, how that authority was given to that particular authority, maybe a class 4 and above officer under SARFAESI or a liquidator appointed by the NCLT. So the description of the property, description of the registered owner, the description and powers of the seller's signatory of the sales certificate, the process conducted by the authority who is selling, the transparency, the eligibility of the buyer, everything should be mentioned in the sales certificate, and then it should be executed. And if it is like not very difficult to get it notarized, and then one copy should be sent to the registration authority, jurisdictional registration authority, based on the location of the property. Now, Vipul Dubey is saying whether a sales certificate which is annexed with a sale deed for auction sale under SARFAESI is liable to be registered, and payment of stamp duty or authorized officer can refuse that it registered. The authorized officer of the bank can always say that I have issued the sales certificate and I have forwarded the sales certificate to the registration authority. Getting a sale deed registered is not required, that the authorized officer can say. However, I have seen in many cases the buyers still request the authorized officer to get it registered in front of the registration authority, and authorized officer I have seen going along with the buyer and getting it registered. However, the Supreme Court judgments say that no stamp duty is required. Registration is the obligation of the registration authority in case the authorized officer, authorized seller, forward a copy of the sales certificate to the registration authority with a direction that it should be registered under section so and so of the Stamp Registration Act. Now, the next question is the DSR, the IRP is asking, can the auction purchaser, if he obtains an EC, will the name of the auction purchaser will appear in the books of the register? Obtain an EC is, I couldn't understand what EC is, as I again will say that the registration authority is under obligation to register. Otherwise, it will go for litigation. What about the registration of movable properties like cars, vehicles? So the cars and vehicles, we are making payment of GST wherever applicable. And in case of vehicles, it has to go to the registration authority, and the registration authority will need all the document which is required for transfer of title of a vehicle under the Motor Vehicle Act. So all those requirements which might even change from state to state, from the office to office, and the procedures may be changed, but all those procedures will be required to transfer a vehicle in the name of a buyer. See, the question is like, Adanki Haresh, have you registered any property without paying stamp duty? No, I have not done it. But then, like I am saying that these three judgments of Honorable Supreme Court, I have given the name, I have given the date. Anyone can see these judgments, and it is very clear that the stamp duty is not payable. Rather, the Supreme Court is saying to the authorities that don't come back to us again and again. We are maintaining the same stand for the last 150 years. As mentioned by you, stamp duty is not payable on sales certificate. However, if paid, can refund be claimed? Now, can refund be claimed is an issue. I think that has to be dealt with the Inspector General of Stamp Duties of each state. It may be a little tardy and slow process, but yes, technically it actually can be a case, an experiment can be done. The other question is, like, once a sales certificate is issued, the rights of the secured creditor will pass on to the auction purchaser. Can the secured creditor still apply for CMM code for taking physical possession? Yes, that is provided under the SARFAESI law that the bank, in fact, the Supreme Court has also held that the bank can sell an asset on the basis of symbolic possession. And the transfer of the title can also be done based on the symbolic possession. And the bank still will have the power to make an application to DM or CJM or CMM for taking the possession of the asset and handing over to the buyer. That powers are still with the bank. If the question is from Hari Prasad, if the property is under mortgage to secured creditor, do we need release, cancel of mortgage from financial creditors while forwarding the sales certificate to the registration authorities by the liquidator? The liquidator, whenever the liquidator sells, that actually means that the relinquishment of the security interest has already been surrendered in favor of the liquidator. Otherwise, the liquidator has got no power to sell an asset during the liquidation process in case the relinquishment of the security interest has not been done. So that means once the relinquishment of security interest has been done in favor of the liquidator, thereafter, no NOC or cancellation of mortgage is required. No cancellation or NOC from the financial creditor is not required. Now, what is the practical difficulty? The practical difficulty is in some cases that asset is still continuously being shown in the records of MCA as there is a charge of the bank on that asset. So the bank should actually, when the bank gets the distribution, the banks should be insisted that they should modify their charge, they should vacate their charge. And in fact, the IBBI is also working that the RP or the liquidator can also file the modification of charge in such cases where the assets are being sold by the liquidator and the charges were created by the banks, because some of the buyers are actually facing difficulties. So therefore, I believe liquidators are also getting some kind of power, and the MCA is working on modification of some of the procedures. Again, the DSR IRP is asking, like, if an encumbrance certificate issued by SRO, the auction purchaser's name should be visible in the EC once sales certificate issued, even if the registration is not done. Neither the sub-registration, the encumbrance certificate issued by the SRO, the auction purchaser name should be visible in the EC. As I said that I couldn't understand what is EC, because these shortcuts, I don't understand the shortcut. Next question is Rajiv Bhatnagar, whether any stamp duty is required to pay if the property purchased under auction by the bank under SARFAESI. I am dealing with the same issue, like as per the 3 judgments of Supreme Court of India, stamp duty is not required to be paid if the property is purchased under SARFAESI Act and the sales certificate is issued by the authorized officer, and that sales certificate has been forwarded by the authorized officer to the registration authority of the jurisdictional area, and then somebody will have to go to the registration authority and get it registered based on these 3 judgments. And if they are not, in case they are not registering, then of course some legal recourse has to be taken. But the judgments of the Supreme Court is very clear that the stamp duty is not applicable. Can the citations and the date of order and the court be told again, sir? Again, I have already told the 3 judgments are there. I can again, I think this is what I can say now, and then I will move on to the other judgments. So I can say the 3 judgments are, one very latest judgment is Haldiram Incorporation Private Limited versus Amrit Hatcheries Private Limited. The date of judgment is 6th of December 2023 from Supreme Court of India. And the other judgment is in the name of SJP Impacts, SJP, ESJAYPEE, SJP Impacts Private Limited versus Assistant General Manager and Authorized Officer of Canara Bank. This judgment is in 2021. And the other judgment, which is the 3rd judgment I am trying to say, is this judgment is in the name of Inspector General of Registration and Others versus G. Madurambal and others. This was decided on 11th of November 2022. So these are, and in this judgment, in fact, the Supreme Court has also kind of passed a stricture that it is the time that the authorities stop filing unnecessary special leave petitions only with the objective of attaining some kind of final dismissal from this court every time. So this actually makes it very clear that the Supreme Court has maintained it, that under Section 89, subsection 4 of the Registration Act and under Section 17, subsection 2 and Clause 12 of the Registration Act, both these sections taken together, read together, it actually can be concluded that only the sales certificate duly executed by the authorized officer has to be forwarded to the registration authority, and the registration authority is under obligation to register the transaction. And once the transaction is registered by the registration authority, sales certificate is issued, then the person who is purchasing the property is in absolute owner of the property, and when he will be selling, there will not be any difficulty in selling that property. I hope it is clear, but yes, still, since there are a lot of questions coming on this issue, I am not interested in going forward till my audience is completely satisfied. I have given the names repeatedly. I can now, Puneet is asking, is it necessary while send a notice under section 13(4) to borrowers, we have to wait for 30 days before initiating the auction process? Yes, the sales certificate is very, very important. This 30 days of sales certificate is very important. The promoter must get 30 days for exercising his right of redemption under the SARFAESI Act. The right of redemption under the SARFAESI Act is mentioned in section 13, subsection 8 of the SARFAESI Act. And that right of redemption is very important, and that should be available for minimum 30 days to the owner of the property. Then we have this Naveen Chand. Is it obligatory on the seller? Is it obligatory on the seller in the auction sale under the symbolic possession to deliver the physical possession to the auction purchaser? To my understanding, if the physical possession is not available, I mean, there are two possibilities. One, that the seller can say that I have sold the property only on symbolic property basis, and I have no obligation to take the possession and hand it over. And in case this obligation is taken by the secured creditor, then he still can apply to CJM, CMM, or DM to get that order and get that property handed over to the buyer. We have a question from Arun Kumar Srivastava. Can bank apply for CIRP under section 7 of the IBC if full debt is not satisfied on sale of asset under SARFAESI Act? Yes. If there is any balance and there is a default, the bank can still go for section 7 application even after all the properties of that particular corporate debtor or even the collateral securities not owned by the corporate debtors are sold. Still, if there is an outstanding amount and that should be more than 1 crore of rupees, and there is a debt, there is a default, and the debt is not being paid, it is section 7. So that also CIRP can be started. Again, Rajiv Bhatnagar is asking, as per recent judgment of Supreme Court, whether the authorities like Noida Authority or SIDCUL can charge transfer charges or not. I believe the transfer charges is a very, very regular thing, and it is paid, it is charged when the sale transaction happens. Now, if the sale, so that means this is not something which was due when the CIRP started. So this is also something which was not due when the sale is being effected through SARFAESI law. So when the sale happens, then only the transfer charges is payable. So the transfer charges can be paid by the buyer, it can be paid by the seller. That becomes that is based on the agreement between the buyer and seller. Yes, these charges are payable because nobody can say that the claim can be filed under CIRP or under liquidation, because there was no outstanding as on the date of commencement of liquidation or as on the date of commencement of CIRP. Therefore, the claim cannot be filed. This is a transaction post-sale. This is a transaction post-resolution. Therefore, the sale transfer charges is genuine charges and it has to be paid. Does any problem may arise if sale as a going concern, slump sale, sale of business in the liquidation? No, we are not, because see, the sale as a going concern does not attract a stamp duty, because that is something which is companies being sold as a going concern by way of change of control and custody and the change of the shareholding. So the stamp duty on new issue of shares would be applicable. However, there is no requirement of selling properties of the company and going to the registration authority for sale. When it comes to slump sale, in the case of slump sale also, the stamp duty is payable, but the slump sale, in case there are properties and the sale certificate issued, I think the same advantage of section 89 subsection 4 and section 17 subsection 2 clause 12 of the registration, because in case of slump sale also the title of the properties has to be transferred. In the case of slump sale, the company is not being handed over to someone. The slump sale means that there is only one amount, and there is no bifurcation of the amount for each asset. So it's a slump sale, but the stamp duty would be payable. This is my clarity about the slump sale. Does this section apply in case of private treaty? I don't think it applies to private treaty. Private treaty, because somehow the word written there is in option. When I see this section 89 subsection 4 and section 17 subsection 2, I don't think it is applicable to private treaties, because the private treaty is not being sold on option. So it has to be an auction process. If a company is sold as a going concern under IBC and the company has a leasehold land from the government authorities, and the government authorities are saying that as owner have changed, so the stamp duty on such transaction has to be paid as per state laws. Now the company is being sold as a going concern under IBC if it is being sold as resolution plan. Then the company is continuing, only the directors are changing and the shareholders are changing. So when the shareholders are changing and the directors are changing, as per some state laws, they are asking for the stamp duty. But this is a case where NCLT can actually come and rescue us, because it is being kept as a company as a going concern. When that law was made, it was only to avoid the manipulation that people used to transfer the shares and they were not transferring the properties. Now it is a resolution, and in this resolution, the shares will be transferred and the directors will be changed. And like there is an amendment in section 79 of the Income Tax Act, yes, I believe in case this particular case can be fought, and the NCLT can also come to help, and this is a good case to fight. So the state governments do not charge stamp duty, saying that it is a kind of illegal method of transferring properties. So therefore, the stamp duty would be applicable. So that also, it makes a good case. It actually, litigation can be started. Maharaj Kumar says, do we need to mention section 89.4 while making application with the registration authority? Yes, we should mention the application to registration authority. We should mention section 17 subsection 2 clause 12, and also we should mention section 89 subsection 4 of the Registration Act, and we should say that the sales certificate has been issued under these powers, and you are directed to register this transaction in book 1 of the registration authority. That is what we must mention to the registration authority. Citations, like as I see, like, yes, I think Shri Kantan has actually given it. I have also given the same citation, Madurambai and the SJP and the Haldiram, all the 3 judgments. In fact, it's all correct. EC stands for the encumbrance certificates, and encumbrance certificates, who will give the encumbrance certificate? I need to understand, Sahuji. The how an haircut is calculated for a resolution plan, that's not a question relevant for today's subject. Under liquidation in case of vehicles mortgaged in favor of financiers, how a liquidator can sell without NOC? The NOC are being asked for. The NOC are, in fact, many of our cases where the NOC was not being given by the lenders. The application was filed before NCLT. So the NCLT finally has given an order directing the motor vehicle registration authority to transfer the vehicle, as the claim has not been filed by the lender. The lender is not in picture, who actually have, we are not even known which branch financed this, but then in NCLT has passed orders that the registration authority should complete the registration and transfer process. See, we have the question is whether the recovery proceedings against the corporate debtor under SARFAESI Act or OTS will be considered for calculating limitation period for the purpose of initiating IRP of personal guarantor. Now, the insolvency resolution process of personal guarantor depends on 3 important bases. One, that there was a personal guarantee given. Second, the personal guarantee was invoked. Third, the personal guarantee, the amount which was demanded by the beneficiary of the personal guarantee that remained unpaid. So these are the three basic requirements of commencing the insolvency resolution process of personal guarantors. Now, in case it has been invoked, and from the invocation, 3 years is the period where the limitation will continue from the date of invocation. I think within 30 days it is supposed to be paid. For barring that 30 days, after 30 days, 3 years. Because this is the action that would have started, because the banker will invoke and wait for 30 days. After 30 days, the bank can take action. So 30 plus 3 years, 30 days plus 3 years is the limitation period. In case the bank doesn't take any action, then the limitation in fact applies. In case the bank files an application before DRT also, then also the limitation actually will considered as continued. Can a cooperative society recover old maintenance charges from auction buyer under SARFAESI? Not really. As per the law, it is not possible to recover any old dues. Most of the buyers, they are in fact trying to settle down with the cooperative societies to continue and avail the benefits of the property. But I understand is that everyone should pay that so that you kind of enjoy that property, and then file an application to NCLT that this particular amount has been coercibly taken from us, and the order should be passed to refund it. Otherwise, the cooperative society is under obligation to file the claim, and that claim would be considered as operational creditor, because the cooperative society is actually providing some services of maintenance. So, and therefore, the amount would be considered as operational creditor. But yes, practically, people are not, because normally the amount is small, so the people are not going for any kind of litigation, because the litigation is also expensive. Now, the other question is like from Vipul Dubey, how haircut is calculated for sole COC member? Will it be calculated on the basis of net payment done? No, that question is not relevant. Haircut is not something which is mentioned in the code. I think this nomenclature is wrong. And why do we need to calculate the haircut? That's nowhere required that somebody is required to calculate the haircut. Hari Prasad is saying, what happens to the security interest created by the financial creditors with SARFAESI? That also has to be vacated. In case the property is sold and in case the security interest is relinquished in favor of this liquidation estate, then the security in that particular registration with the SARFAESI central registry will also have to be vacated. Naveen Kumar is saying, with reference to your answer about taking the case to NCLT if company is sold as a going concern under CIRP and challenging any demand of stamp duty on change of ownership, will the situation be same if it is sold as a going concern in liquidation? Yes, it will be the same, because the sale of the company as a going concern during liquidation process is akin to resolution plan being approved. So everything remains same. A couple of processes are different, and therefore it will be considered as akin to resolution plan. And it is actually with the order of a court. So when the company is being transferred with the order of a court, that actually means that it is not for manipulating the need of paying the stamp duty as it used to be. So therefore, the help will definitely be given to the buyer from this kind of state law. I understand in Uttar Pradesh, a lot of people, they were selling properties only by selling in many states, by selling the companies itself. The threshold of personal guarantor is not 1 crore. I believe it is still 1,000 or 10,000. It is not 1 crore. It is 1,000 or 10,000. MP Jindal is asking, is limitation applicable for application under Section 94 for personal guarantor? Though no limitation is applicable for personal guarantor, because he actually is a debtor. So he is not taking the benefit of the limitation period. He is trying to raise hand, and he's trying to file an application that I am insolvent, I want to resolve my case, or I want to go and declare my bankruptcy. So the limitation period is not application under Section 94. Then again, the DSR is asking, if the bank issues Section 13.2 and 13.4 notices for both company assets and guarantors collateral combinedly, and if the company goes into CIRP, can earlier notices under SARFAESI will still be valid? collectively notices, yes, those notices would still be valid because the particular properties as required to be mentioned. That property description must be mentioned, so that particular notice would be valid. Ranjan is asking whether Section 32A come in rescue for buyer for any demand raised later of past dues. Section 32A is only applicable to investigating agencies against the criminal offences. Rajiv Bhatnagar is asking, in case of liquidation, whether the stamp duty shall be payable if the buyer purchased the property from the liquidator and the Haldiram judgment shall apply. Although there is no judgment as of now, I repeat, one, that the SARFAESI is the assets are being sold by the authorized officer, and the authorized officer is issuing a sales certificate, and the sale is being made under the auction. So these are the three conditions when we read Section 89, subsection 4 and Section 17, subsection 2, clause 12 of the Registration Act. These three things are almost similar to SARFAESI in the liquidation also. The sale is being made by an officer appointed by the court. The sale is also being handled by the auction. The sale certificate is being issued by the officer of the court. So I believe when we are selling in the liquidation, this three judgments of SARFAESI Act should be applicable to the liquidation sales also. I'm moving on to the another judgment, which is from Honorable Supreme Court of India, 𝐃𝐄𝐋𝐈𝐁𝐄𝐑𝐀𝐄𝐑𝐀𝐓𝐒 versus Honest Shelters Private Limited. And this is the judgment from 6th of December 2023 from Honorable Supreme Court of India. Now, the 𝐃𝐄𝐋𝐈𝐁𝐄𝐑𝐀𝐄𝐑𝐀 is the RP, and the Honest Shelter Private Limited is the corporate debtor. And in fact, on June 26, 2019, a sales certificate was issued under SARFAESI Act. And in that sales certificate, 142 apartments in the Sky and Manor situated in Worli Estate, and which was assigned to the Honest Shelter Private Limited. Now, Honest Shelter Private Limited, in fact, it's a case where the land was mortgaged, and 142 apartments were the total two projects, Sky and Manor, that was assigned to Honest Shelter Private Limited. Honest Shelter Private Limited started selling those apartments, and the SARFAESI law, and then finally the RERA came in picture. This Honest Shelter Private Limited registered these projects under RERA, and the RERA also issued orders which was dated 20th of March 23 and again 19th of July 23, where the RERA directed Honest Shelters to complete the project and hand over possessions to the flat owner. Now, the RP of the Honest Shelters Private Limited, in fact, argued before the court that these properties which are excluded by way of a sales certificate, that should become the properties of the corporate debtor, and that should be which is for the resolution. Although, but I feel 𝐃𝐄𝐋𝐈𝐁𝐄𝐑𝐀𝐄𝐑𝐀 was right, because the 142 flats were assigned to the corporate debtor, and then it should be the assignment was done. Although it was not owned, but there was a contractual right available with the Honest Shelter, but the respondent, like the Honest Shelter, says that because see, these 142 flats are sold to the buyers. They have created their rights. Third-party rights have already been created. They have paid their dues. So therefore, the sales, it was excluded from the sales certificate. And secondly, the RERA has also directed me to complete and hand over to them. So therefore, the legal issue, what Honorable Supreme Court saw in this case, whether the property is excluded from the sales certificate issued under SARFAESI Act, could be included in the insolvency proceedings under this insolvency law. Now, the court finally, in fact, said that in view of the RERA order and in view of the third-party rights of the home buyers who have paid the money, so therefore these 142 flats should be kept excluded from the insolvency process. Now, when I see this, this judgment is also having some implication on real estate cases, because see, what I'm trying to say that the Supreme Court has again reiterated their sympathy and their care for the home buyers. Look, why I'm saying so? Because see, right from the day one, the home buyers were considered as financial creditors. Then, in the case of Amrapali's, the Honorable Supreme Court said that the first is to complete the project. Thereafter, the secured creditors will get anything. So that means virtually the home buyers' project completion and handing over of the properties or the units, that actually became even top priority, even better than the secured creditor. And then in this case also, even the 142 flats, in fact, would not be even considered as part of the liquidation estate. So this is something which is again very important, that the Supreme Court is very clearly, very clearly, Supreme Court is saying that yes, they would care about home buyers. Now, another case which is important is Silir LLP versus Bafna Motors in bracket Mumbai Private Limited. This judgment is dated 21st of September 2023. It is from Honorable Supreme Court of India and from the Chief Justice of India. So this is again very important, that again I said in my today's deliberation that section 13 subsection 8 talks about the right of redemption of the owner of the property, right of redemption of the mortgager, that the right of assumption of the borrower. Now, the right of assumption under section 13(8) can be exercised in respect of secured assets up to what point of time? Now, in this case, let me first of all say some of the facts of the case. SARFAESI action was started because of the default. The auction notice was published 9 times, and it was auctioned for a price of 105 crore. Now, the appellant, one of the person who participated in the auction, and he purchased almost at reserve price, and he was declared as the auction buyer. He paid 25%. Then, when he paid 25%, then the borrower filed a kind of redemption application under section 13 subsection 8 before the debt recovery tribunal to redeem the mortgage by paying 123 crore, because he wanted to pay 123 crore. Maybe that is the only outstanding, so that he wanted to redeem that particular asset. Now, this was filed before the then the borrower also, because of the delay, or because of the borrower also filed a writ petition before the High Court and seeking the direction to the bank to permit redemption by paying 129. So another 129 offer. High Court in fact permitted the borrower to redeem the mortgage and allowed them to pay 25 crores immediately, and rest was 104 crore within some days. Then the person who bought it through the auction at 105 crore, he approached Supreme Court of India, and the Supreme Court of India said that the failure to tender the entire dues before auction notice is the first requirement after the SARFAESI was amended. The SARFAESI law was amended in year 2016. So after this amendment, now it has to be exercised. The borrower can pay the total amount, can take the property back under section 13, subsection 8. But that right is restricted after the amendment. It is only restricted before the auction notice is released. In this case, auction notice was released, 25% was paid, the auction was also conducted. Therefore, the particular judgment of High Court was not only completely quashed, in fact, High Courts were also kind of directed not to entertain Article 226 petitions if the SARFAESI Act remedy is available. Article 226 petitions should not be entertained. That is what Supreme Court of India asked high courts to resist from invoking or entertaining Article 226 petitions. So the decision was very clear that the right of the borrower to redeem secured asset is extinguished. So the purchaser who purchased the property at 105 crore, he becomes the owner. And also the Supreme Court noted that the banks are also having kind of very loose kind of behavior. Before the DRT, they were saying that they were opposing. Before the High Court, since the amount was offered was 129, they were consenting. So in fact, they noted that this kind of behavior of the creditors are also not appreciable. So this is where when the banks in fact tried to play only because the recovery is higher. So that is what was also like kind of targeted by Honorable Supreme Court. Now, one thing which is very clearly being told by the Supreme Court of India in many other cases, that when when high courts are in fact entertaining the writ petitions under Article 226 of the Constitution of India, wherever e-auctions are being conducted or possessions are being taken. So when the Section 17 of the SARFAESI Act says that there is a remedy available and that remedy should be exercised, but that actually is not coming forward. So it is again in the case of 𝐃𝐄𝐋𝐈𝐁𝐄𝐑𝐀𝐄𝐓 versus State Bank of Hyderabad on 2nd May 2023, the Supreme Court of India said that the High Court should actually not intervene into various issues, and when the DRT is available, the DRT should actually handle all these matters, and should not be very kind of apparent that the high courts are indulging into all this. We have many more judgments, and in fact, like in the next episode also, we would complete this part along with another issue which is very important, that is the contempt issue. In fact, along with the contempt issue, we will also kind of handle some of the issues on the SARFAESI law. I will take a couple of questions, then I would see the Shalinder Singhal is asking, in case going on under Section 150 under Section IBC, can we initiate case against the personal guarantor without invoking guarantee? What do we mean by invocation of guarantee? No, invocation of guarantee is very important by the beneficiaries. If the personal guarantee has been given to a bank, the banker will first invoke the personal guarantee, will raise the demand notice, and after 30 days of the raising of the demand notice, only Section 95 application can be made. MP Jindal is asking, what is the difference between resolution plan in CIRP and the sale of the... No, the only difference is that in a resolution plan, the amount can be paid in 2 years, 5 years, 10 years. In the case of liquidation as a going concern, and the maximum period is 90 days. And in the liquidation period, everything else remains, but somehow I feel that in a resolution, we can say that the existing share capital of the company will be transferred at 1 paisa to the new successful resolution applicant. Whereas in the case of liquidation, since that part may be that we have to extinguish the share capital and we have to issue new share capital to the buyer. So everything else remains same. The company has to be kept as a going concern. All the financial statements are supposed to be prepared. All the compliances of income tax department, ROC department has to be done. So everything remains the same. The resolution plan or sale of the company as a going concern, the payment time cannot be more than 90 days unless NCLT approves it. So then I think we have to finish it. And although there are many questions, and the interaction from people, in fact, is increasing, and we are also enjoying taking questions. So I think some of the questions can be taken in the next Saturday at 11 a.m. Thank you very much. Have a nice weekend.